Good morning or good afternoon, everyone. I am Barb Grandjean. I am coming to you from a virtual spring break location somewhere, which is not really true. I'm a partner in the Denver office. And I'm joined here by Jenna Brofsky, who is a partner in our Kansas City office. And before we begin, I have a few housekeeping items that I need to cover. At the bottom of your audience console, there are multiple application icons for your use during the program today. If you have any questions during the webcast, please submit them via the question box. If we can't get to it today, we'll do our best to follow up later, or maybe we'll even have another webinar because this is a busy topic. The PDF of the presentation is available in the Program Materials folder on your screen. Auto-generated closed captions are available for today's program. To turn on those closed captions, you click the CC button in the bottom right corner of the media player box. This program has been approved for legal education hours. For live attendees, you're going to report your hours by clicking on the CEU icon at the bottom of the screen, and a certificate of attendance, including the course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing with all of your friends, and on Friday night with popcorn and a glass of wine. Toward the end of the program, please be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your business needs. And with that, I'll turn it over to Jenna to get us started.
Thank you so much, Barb. Welcome to Understanding the Pregnant Workers Fairness Act in 2025 and beyond. We're going to start with the agenda, but first, this photo. This is me in 2023, 9 months pregnant at the Kansas State Fair with a cow who's also 9 months pregnant, because for the Kansas State Fair, they breed the animals so that they give birth at the state fair, which is very cool. And in any event, we were commiserating the 9-month pregnant cow and I about our state of being. And I'm sure she would be interested to hear how the Pregnant Workers Fairness Act applies to cows. It does not. What we're going to talk about today is, what is the Pregnant Workers Fairness Act? What's the status of the law and guidance under a new administration and a new commission? What requirements exist for healthcare organizations and other laws that cover pregnant workers? And when I say requirements for healthcare organizations, we'll talk about requirements for all businesses. We'll do a few hypotheticals in the healthcare space, and then we'll talk about the EEOC guidance specific for healthcare providers and the PWFA. So what is this rule or this law that we're talking about? So this was kind of an incredible bipartisan effort. You had Chuck Grassley, Mitt Romney on the Republican side co-sponsoring with pretty left Democrats to say, we want to provide some kind of protections for pregnant women. So after this became a law through Congress, it took effect in June of 2023. Under the Biden administration, the EEOC went about creating a rule. So they went through the notice and comment rulemaking process. In that process, they received like 100,000 comments, which is a lot of comments for this type of rule. And then they issued a final rule, which was pretty similar to the proposed rule. It was voted in the EEOC on a vote of 3-2 along party lines. The EEOC normally has 5 members. As you'll soon hear, or as I'll tell you now, it currently has 2 members. So with the new administration, if you haven't heard, there's some new approaches to a lot of things happening, and that includes the EEOC. So in that 3-2 vote, one of the no votes was the now chairwoman, Andrea Lucas. So now she is in charge of the commission. And Andrea Lucas wrote a really long explanation of why she voted against the PWFA final rule. She says again and again that she agrees with protecting pregnant women. She says the PWFA was a tremendous bipartisan legislative achievement. So she wants this concept. Her focus is on the, quote, minor, simple, temporary accommodations for pregnant workers, water, food, place to sit, that allows women to continue working. So she is on board with this concept, but she doesn't like the actual final rule, the way that it's written. And in short, she finds that it's too broad in what it covers. Her concern is that it covers not just women while they're pregnant, but women's capacity for pregnancy to become pregnant. She's concerned about the scope of the rule, and she just thinks it's too broad. And interestingly, Andrea Lucas is a mom and gave birth to her second child while on the commission. So that I think is insightful. So I'm going to pass it to Barb to talk about what was the purpose of this law.
Thank you, Jenna. So one of the purposes of this law was to fill the gaps that existed in the legal protections for pregnant workers. And we'll discuss toward the end of the presentation some of those other laws and the gaps that those laws created that pregnant women could fall through. And we'll also talk about some of the intersectional issues between those laws and the PWFA. The other purposes, as Jenna mentioned, pregnant workers should not have to choose between a healthy pregnancy and a paycheck. So the idea behind this law was to give women the opportunity to work longer into their pregnancies as long as they want to, and including the whole time. And so that we shouldn't be putting up artificial barriers or not giving pregnant women the opportunity to get what they need to be able to continue working. But as you're going to learn, the final regulations that were ultimately approved have gone much further than just those simple things, the minor assistance that could be expected from common decency and good manners. And it ends up covering quite a bit more. And so you're going to learn that these final regulations are likely to change as a result of lawsuits and potentially because of the new administration. So a couple quick facts. This is a really good topic for healthcare employers. I know we have a lot of other folks on the call too, but healthcare employers tend to have a large female workforce. So if we start with the idea that 23% of moms have thought about leaving a job due to lack of reasonable accommodations or a fear of discrimination from an employer during pregnancy. So 23% of these moms would be dropping out of the workforce if it were not for laws protecting them. There are 2.8 million pregnant women per year in the US. 80% of those first-time pregnant women work until their final month of pregnancy, and 72% of all working women will become pregnant while in the workforce. In the healthcare industry in particular, 78% of US healthcare jobs are held by women, and 88% of registered nurses are women. Jenna?
So let's jump into it. Let's start with which organizations are covered. It's the same definition as Title VII of the Civil Rights Act. So if you employ 15 or more employees, your organization will be covered. And that includes both private employers and public employers. And then you see an asterisk there. So this is kind of interesting. The state of Texas brought a lawsuit, and it's currently on appeal before the Fifth Circuit, stating that they didn't believe the PWFA, the statute, the congressional act, could be upheld because they believe there wasn't a quorum at the time the PWFA was passed. The PWFA was passed as part of a large omnibus bill, but the state of Texas only challenged 2 provisions, and the district court agreed with Texas. So right now, the PWFA is not enforceable against Texas state employees. So if you work for the state of Texas, you work for a Texas state health system, for example. However, private employers in Texas are subject to the PWFA. So that's an interesting carve out. Oral argument was just heard last month. So you can stay tuned for an answer on that if you are in Texas. And the PWFA covers both for-profit and nonprofit organizations. So which workers are covered? We talked about the fact that cows are not covered, but pregnant employees are covered. And those include people who are already working for an organization or those seeking employment, what the statute and the regulations refer to as applicants. How about former employees? Well, again, we're looking at the Title VII definition, and former employees are technically covered. How would that come up? In the final rule, the example given by the EEOC is that if a former employee wants to file a lawsuit under the PWFA, the employer can't say, well, we'll give a negative reference to your future employer if you file a lawsuit. So it goes into the world of retaliation. That's really where former employees will come into play. So we're talking about employees who are pregnant. So let's start with what conditions are covered during pregnancy. And the language in the statute is physical or mental condition related to, affected by, or arising out of pregnancy, and we'll get to the rest of that. But in terms of pregnancy, we're thinking of what pregnant women undergo, having to use the bathroom, gestational diabetes, mental health conditions such as anxiety or depression. miscarriage and abortion are both explicit examples in the rule themselves. There's no examples in the statute, but those would tend to arise out of pregnancy, because I would imagine that ending a pregnancy is impossible without being pregnant in the first place. And it's a good place to note that to the extent the rule does go away or get modified, the language in the statute, as you see, is pretty broad and related to, affected by, or arising out of. So I suspect that a court would be the one to interpret that language absent rule language. All right, Barb, what happened? But wait.
The rules related to abortion are already being challenged with some success. This first case we wanted to talk about is Tennessee versus the EEOC. And that was 17 Republican attorney general who objected to this law because it made them provide reasonable accommodations for state employees seeking an abortion in all circumstances, including elective abortions. This case was initially filed under the Biden administration. The EEOC is represented by the Department of Justice. And the attorneys general argue that the rule is unlawful, either because it's arbitrary and capricious, because the agency's definition of related medical conditions exceeds the EEOC's authority, and the rule violates the First Amendment and constitutional principles of federalism. The trial court actually said that these states didn't have standing to challenge the rule, and they wouldn't have standing until they actually had to address a request from an employee for an abortion-related accommodation. The Eighth Circuit Court of Appeals just last month said, no, that's not the case. In fact, these states do have standing to challenge this portion of the rule because they're injured by the imposition of new regulatory obligations. They need to train people, they have to comply with these regulations, and so they do in fact have standing to challenge it. So the Eighth Circuit sent the case back down to the trial court now that standing has been resolved. And what's interesting is that the EEOC, now we have a new administration, we have Andrea Lucas in charge, and it's going to be interesting to see whether the Department of Justice continues to zealously support the rules that the earlier EEOC passed. And the EEOC, when asked about this standing issue, actually declined to comment on the rule and referred reporters back to the chairwoman, Andrea Lucas's comments that the rules go too far and they conflate pregnancy and childbirth accommodation with accommodations that are related generally to the female sex, female biology and reproduction. So we will see if the EEOC continues to try to support the rule related to abortion. Another but wait is also a challenge to the abortion provisions in the rule and also IVF. And this case was brought by the Catholic Benefits Association, which is a nonprofit membership organization that purports to represent 162,000 employees in health plans. And this case basically hinged on the Religious Freedom Restoration Act. And these Catholic organizations are arguing that they shouldn't be required to speak in support of or to provide accommodations that would conflict with their religious beliefs. And in this case, that includes accommodations related to infertility treatments such as IVF and abortion. They also challenged some Title VII, the recent sexual harassment, sexual orientation regulations that came out by the EEOC last year. And so this is the first case so far with regard to the limited pool of Catholic plaintiffs that have blocked the mandate for leave on infertility treatments too. So you don't, if you're one of those parties, as of now, you're not accommodating IVF as part of your employment practices.
Thanks, Barb. Thanks, Barb. So we talked about conditions during pregnancy. The law also includes conditions related to, affected by, or arising out of childbirth. which would include any type of delivery, vaginal or cesarean, any mental health condition, postpartum depression, baby blues, anxiety, and as well as feeding your child through lactation and the myriad of other conditions that can result from breastfeeding or nursing. So here's the full quote: physical or mental condition related to, affected by, or arising out of pregnancy, check, childbirth, check, or related medical condition. What does that mean? These are some examples of the EEOC's rule and the comments to the rule touch on. Endometriosis is one example, and I think that one is interesting because that is one where perhaps it doesn't get diagnosed until after childbirth. So would that be a related medical condition? Fertility treatments, which Barb has mentioned, use of contraception. So is this rule broad enough to cover things like insertion or removal of an IUD? And then depression, anxiety, or mental health conditions that aren't specifically related to the pregnancy or childbirth. And I think that's a question that the courts will be grappling with. So what is the standard? So there's 2 bullet points, and I'm going to group these into 2 categories. The second is undue hardship, and we're going to put that down for right now and focused on kind of the first bullet point. Covered organizations, so 15 or more employees, must make reasonable accommodations, and that's a key one, to the known limitations related to the conditions we just talked about. So we'll work backwards. The known limitations means that the limitations have been communicated to the employer. There's no special words when requesting an accommodation, and Barb will speak in a little bit about what documentation you might want to get and what documentation you probably don't want to get. Now, in terms of what's reasonable, this is the fun part. If you've turned to look at what executive order is coming out next, please focus back in. You'll want to pay attention here. So the EEOC has a few categories, or 4 categories of accommodations that they call predictable assessments, which is kind of a complicated term, which really means in virtually all cases, the EEOC is going to consider these to be reasonable. In virtually all cases, the EEOC will find that allowing an employee to have water and food with them near their workstation is going to be reasonable. Same thing for taking bathroom breaks and allowing an employee to sit if their position requires standing, or to stand if their position requires sitting. Same thing for allowing employees breaks to eat or drink. Now, in terms of the first example, having water or food with you being virtually always reasonable, I can certainly think of a situation where, the doctor in the OR wants to eat a Snickers bar while he's operating. Of course, that's not going to be reasonable for her. And perhaps in that kind of situation, it would be allowing her a break. So there's always, when you're talking about reasonableness, even in this virtually all cases, there's always fact specific. The second accommodation that I think folks are interested to hear about is leave. Leave is possibly a reasonable accommodation under the PWFA, but again, it's going to go to the circumstances. Now, what is specified in the law is that employers cannot require employees to take leave if another reasonable accommodation can be provided. So it's going to go to this interactive dialogue, the conversation that you're having, and what are the options for a particular employee. Again, leave may be reasonable, but you cannot, as the organization, require someone to take leave if they can continue working as with a reasonable accommodation. The third bullet point here speaks to something that I see we're getting a few questions about, and that's suspending a temporary job function. So if you're familiar with the ADA, you're saying, oh my goodness, temporary essential job functions, no way, no how, we're not letting those go. Under the PWFA, it's a little bit different of an analysis. So the statute says that employees are still qualified employees under the PWFA, even if they can't perform an essential job function temporarily. And that if they can perform it in the near future, that's the language, why I use the air quotes, then perhaps they're still entitled to an accommodation. What does near future mean? So the rule defines near future as generally 40 weeks, because generally pregnancies are 40 weeks, but obviously not all pregnancies are 40 weeks, and likely employees aren't coming to you when they're technically pregnant for a week and asking for an accommodation. And at the same time, this rule includes accommodations after pregnancy, for example, related to lactation, and that doesn't in any meaningful way relate to the 40 weeks. So it's really fact specific. But the important thing to remember is that it is possibly reasonable to suspend a temporary job function if the employee will be able to perform that essential function in the near future and all the other requirements are met. For example, that there's no undue hardship. But it's a little bit different than the ADA, and we felt like it was important to discuss that here. All right, we're going to share a case with you. Go ahead, Barb.
Yes, before I do that, Jenna, we did have a question about morning sickness.
Okay, well, I didn't see the specific question, but I will say that morning sickness is covered as a condition arising out of pregnancy. And as most folks know, it probably doesn't happen exclusively in the morning.
Yep, thank you. Okay. IRL, the kids tell me that means in real life. So we're sharing with you some of the cases that the EEOC has filed under the PWFA and these regulations, just to show you the types of things the EEOC is interested in. It's important as I talk about these cases that most of them are still pending. And so I'm going to tell you about the allegations in the case. There has not been a decision made by a judge or a jury, but these are allegations. So this first case is a freight transportation and logistics personnel provider doing business in Illinois. And in this instance, a driver alleged that she was being discriminated against and they were failing to reasonably accommodate her pregnancy-related restrictions, and they placed her on an involuntary unpaid leave. The EEOC, after getting the charge, took up the investigation, and this is a subpoena enforcement action, which means that the EEOC attempted to subpoena records from the employer, and that was not successful. So the EEOC has gone to court to file this enforcement action. And what they're seeking is information about other employees who requested accommodations for pregnancy-related restrictions in 6 different states. And Jenna and I thought this was interesting to bring to your attention because I think there's a little bit of a disconnect between the EEOC's position that many of the accommodations, the virtually all situations, are going to be quick and easy and wouldn't necessarily be something that an employer is tracking. But at the same time, in this case, the EEOC is seeking information about other pregnancy-related accommodations and restrictions across the organization. We also think there could be some risk associated with the document retention in this case. Do you want to address that, Jenna?
Yeah, absolutely, Barb. So there's no requirement in the PWFA that employers are keeping track of these accommodations. However, once they're in your possession, custody, and control, and if they contain medical information or health information, we're back in the world of the ADA, meaning these have to be held confidentially, they need to be held separately. So there are a lot of requirements attendant to having this information once you choose to collect it. Back to you, Barb.
Yep, okay. Our next in real life ongoing current case, again, based on the allegations in this case, the EEOC has filed a lawsuit against this medical practice in Oklahoma. And in this case, the medical assistant had a high-risk pregnancy and requested certain accommodations. She requested more frequent breaks, but she was told that there's no breaks, guaranteed 30-minute breaks for medical assistants, and they could take a break if it aligned with patient schedules. The employee was experiencing substantial swelling, pain, and discomfort in her feet, legs, and abdomen, and was eventually diagnosed with placental insufficiency. So as a result, she wanted to take more frequent breaks. She needed to sit down. She was told that medical assistants at that practice need to stand 90 to 100% of the time, and she could sit if there was extra time. She could take meal breaks, but only if the provider she was assigned to that day was going to be taking a meal break. And then there's also an allegation in the complaint that she was told things like sitting and eating are not part of your job description. So allegedly, this practice put her on an unpaid leave of absence. She was interested in coming back and requested that the practice guarantee she would be given the ability to take meal breaks and time to express breast milk. And the practice allegedly refused to do that. And so she quit. Actually, she did not quit. The employer fired her because she refused to work if they wouldn't guarantee her the ability to express breast milk upon her return to work. This case is ongoing, and I think we can probably glean from some of these allegations things that employers probably should not be saying when they're receiving requests like this from an employee.
Thanks,
Jenna.
Barb. Thank you. Before I jump to undue hardship, we're getting a lot of really great questions about reasonableness, so I want to talk through that a little bit. Stepping back a second, the policy, right? If we look at the policy and it's to keep women working as long as they can and making money, just keep that in the back of your mind, because some of these questions are about things like reassignment, which very well may be reasonable because it would allow the employee to continue working during their pregnancy and in this stage of their life. There's questions about how much time an employee should be able to get off, and that is very, very fact specific. For example, how many hours they're generally working, what are the needs of the position, what are the needs of the organization, and for those really fact specific questions, to the extent you want to talk with Barb and I offline, we're happy to address those individually and provide a deeper analysis. There's an interesting question about an employee requesting an accommodation of work from home to breastfeed. Again, whether that's reasonable or not will depend on the circumstances. What is the employee's position? Are they a physical therapist that needs to be with patients in person? Obviously, that would be challenging to do from home. You also hit on a related law called the Pump Act, which we're going to talk about at the end, but does require employers to provide a space for an employee to pump. And it's very specific that it can't be a bathroom and it has to be private and it has to close. So it would seem that there's another perhaps reasonable accommodation for that employee. And as we all know, if there are multiple accommodations that are reasonable, the employer certainly has the ability to pick one of those reasonable accommodations. Okay, so let's talk about undue hardship. Undue hardship has the same meaning as under the ADA, and it means significant difficulty or expense in light of the factors, and these are in the regulations for the ADA. So what courts or the EEOC will be looking at is what's the cost of this accommodation? Are these, I think about if somebody needs a quiet space, are these $200 headphones, or are these, you need to build an entire new wing of the hospital for me to work in? What's the overall financial resources of the facility or facilities involved? What's the overall financial resources of the covered entity? So in that factor, perhaps we're looking at the entire bigger organization, the type of operation, including the composition, structure, and functions of the workforce, and geographic separateness and administrative or fiscal relationship of the facility or facilities in question. That's a lot of words. Essentially, what that fourth bullet point means is this facility operating kind of separate and apart from the greater organization? And is it fair to look at that specific facility to determine how or what the hardship would be on the employer if they were to grant a specific accommodation? And then the impact of the accommodation upon the operation of the facility, including impact on the ability of other employees to perform their duties, and the impact on the facility's ability to conduct business. And if you were at our webinar, I think it was in December, Barb gave a really interesting example of a department in a hospital where there were several nurses, and for various reasons, they each had to go on leave, or each were requesting to go on leave for different reasons. And that goes to the ability of other employees to perform the duties of an employee who's seeking an accommodation under the PWFA. Timing is everything. So the law states that undue delay could amount to denial because pregnancy is inherently temporary in nature. So consider whether a temporary accommodation makes sense. It's really important when an employee asks for an accommodation under the PWFA to timely respond, even perhaps to acknowledge and to consider something temporarily until there can be additional conversations had. The statute also states that damages are limited if there is a claim made, so long as the employer has provided a reasonable accommodation and made a good faith effort to do so. So it is worth making a good faith effort to do so as a risk mitigation proposition. So let's jump into a hypothetical. If we were in person, I'd have somebody else read this, but you're going to have to hear me read it. Molly is 27 weeks pregnant. That means she is in her second trimester. And she applies online for a nurse practitioner position at Healthy Hospital, which is not a real client. She is selected for an interview based on her strong credentials, and she arrives at the interview in her best maternity attire. She informs Healthy Hospital that she will not be able to start until 10 weeks after giving birth. The job posting that she used does not include a start date. Okay, first of all, Molly is not currently employed with Healthy Hospital. Well, she is an applicant to Healthy Hospital, and therefore she is generally covered by the PWFA. So now we kind of start the analysis. Let's say that Molly didn't tell us that she was pregnant and that she wouldn't be able to start until 10 weeks after giving birth. Well, we certainly don't want to make any assumptions or stereotype. I think we can all agree that that's not helpful. But to the extent Molly tells us these are her requirements, then we're thinking about, okay, what is reasonable here? What is the expectation for this job? Is this job supposed to start in 2 weeks? And even if it doesn't say it on the job posting, perhaps the expectation is that the job is to start in 2 weeks. And there's no hard and fast rules here. There's so many different variables, but what we wanted to point out here is that the rule does cover applicants and that we should be considering whether it's reasonable and whether there would be an undue hardship. I mean, perhaps it's not reasonable for Molly to not start for another 13 plus 10, so 23 weeks, but what if Molly asked for like a week or two? Would that be reasonable? It will depend on the facts and circumstances. All right, Barb.
Okay, back to another EEOC filed case. On September 25th of last year, EEOC sued Polaris Industries in the Northern District of Alabama. And the claims were under the PWFA, alleging a failure to provide a reasonable accommodation and then constructively discharging this person. She was a new employee at an assembly facility, and she notified her employer at the new employee orientation that she was pregnant and would have limitations. So this employer knew as of orientation of her known limitations. She alleges that she was not excused for absences due to her pregnancy-related conditions and medical appointments. She was in her probationary period, and the employer assessed attendance points against her because she didn't have a time off that she could take for those pregnancy-related medical conditions and appointments. She alleges she was required to work overtime despite medical orders to not to work more than 40 hours in a week on a temporary basis. And HR told her when she asked to not have to be working overtime, she was told overtime is an essential function of the position. So she eventually resigned in order to not be fired. So this, I think, illustrates again the EEOC's focus on some of the things that Jenna talked about. One of them being the idea that an essential function of a position may actually need to be waived for a period of time under the PWFA and its regulations. And then also this idea that the employer she doesn't have time off like everybody else does because she's in a probationary period. So nobody in the probationary period has time off available to them. But again, given the PWFA and its regulations, I think she probably is entitled to be able to take time off for her pregnancy-related medical conditions. So we'll see. We'll be watching that case to see how it turns out. Jenna, this is back to you.
Thank you. And first of all, it's so fun to have such an engaged audience. Lots of really great questions. So thank you. We're trying to read through them all. I will clarify as to undue hardship. The question was whether you had to meet all of those different bullet points. And the answer is no. It's fact specific. It's going to depend on the circumstances that apply in your situation. There's also a really good question about a cleaning job, I believe, and whether that job doesn't allow, if that job doesn't allow the employee to sit How can you possibly accommodate that individual? Again, this is not legal advice. I don't have all the information, but what I would think about is whether there's some other position that that employee could do for a period of time if the employee can show that after or in the near future, she will be able to do that job. Maybe it's a leave of absence, and maybe there's nothing that can be done. Again, without all the information, it's hard to say, but I think thinking creatively, which it seems like we're all doing, is critical. So hypothetical 2, Papa Don't Preach by Madonna. Here's the hypothetical. Samantha is a physical therapist at the community hospital. Her hourly rate is $40 an hour. She informs her employer that she's pregnant, and she requests not to lift more than 25 pounds. Her job description expressly requires lifting, and all of her patients weigh more than 25 pounds. The community hospital would like to place Samantha in a light-duty position as a receptionist, which pays $26 an hour. Alternatively, they can place her in a position that pays $40 an hour, but requires her to work overnight monitoring patients during sleep studies, and she currently works only on the days. So this kind of gets at that idea of job transfer, reassignment. What can we do? I think the community hospital is thinking really well and doing a good job of saying, how else can we get this person employed, keep this person working during her pregnancy? Obviously, she's not going to be able to do exactly what she was doing before, so she's asking for an accommodation. In the first example, paying a lower rate in a different job, a light duty position, is a question that I've been asked. And while there's nothing in the PWFA specifically on this point, if we look at the ADA case law, that states that a change in wage to match light duty job is permissible. So going off of that case law, that would seem to be reasonable. Additionally, changing the hours but keeping the pay the same may also be reasonable. The question that I have in this hypothetical is, was there a conversation or an interactive process with Samantha to understand if kind of what her interests are and if she's interested in taking any of these accommodations, which may be reasonable in her circumstances. Okay. No discrimination, no retaliation, no assumptions, generally good advice across the board. There is a specific provision in the PWFA that organizations or employers can't take adverse action in the terms, conditions, or privileges of employment on account of an employee seeking or using a reasonable accommodation, one that is included in the statute. We talk about in terms, conditions, or privileges of employment. We're talking about termination. We're talking about demotion, those type of actions that you're probably familiar with from other discrimination statutes. In addition to the prohibition on discriminating or retaliating, it's also important not to assume really anything. My mom would say, if you assume, you make a, I won't finish the rest of that statement. Per the rule, you can't excuse a pregnant employee from overtime as an accommodation without the employee seeking an accommodation and the employer and the employee engaging in an interactive process. So I think there probably will be situations where employers are good-natured and thinking, oh goodness, that employee probably isn't going to want to take overtime or probably isn't going to want to travel or whatever it might be because they're pregnant, coming from a really, really lovely place. Unfortunately, that's not how to comply with the law. So we don't want to excuse, we want to go through that interactive process. So what is this interactive process that I've stated 10 times already? Well, first, why? Risk management, but also critical to workplace dynamics. Being able to communicate with your employees about what it is that they need and what it is that you can provide as the employer will lead to a more efficient workplace. So the interactive process means that there's a conversation. It doesn't have to be in writing. Sometimes it's really helpful to have things in writing. That would probably be a best practice. Understanding what it is the employee is looking for and what it is the employer can do. And that includes asking the employee for her suggestion. At the end of the day, that might not be reasonable, but it's good to ask the question. And it involves evaluating your options. Again, what is reasonable in the particular circumstances? What is this employee's position? What is it that they're saying they can't do? Will they be able to do it in a month or 2 months or 9 months. And then once you do implement the accommodation, it's good to document in writing what the accommodation is and how long it is for. For instance, we're allowing this employee to take a unpaid leave for X number of days, or we're allowing this employee to take off for some appointments that she has toward the end of her pregnancy. And this is temporary in nature because we know that after she's given birth, she won't need to go to those appointments anymore. Barbara, back to you.
Okay, so I don't want to throw us off time because we still have a lot to cover, but thank you to the person who gave us a shout out for being fabulous in the comments. We love that. Secondly, there was a question, and it feels like it's a trick question, but it's not a trick question. What is the impact of the PWFA on fathers or men in the workplace? And the answer is nothing, none. And Jenna, you argue with me if you want, but until men can get pregnant, this law protects pregnancy and related medical conditions of the pregnant person. And so that does not involve the father or the, the male. Although something like the FMLA may give the father rights related to the birth of a child, but the PWFA itself does not have an impact on men or fathers. And Jenna's giving me the thumbs up, so yay, I did it right. Okay, another EEOC case. We're going to talk about medical documentation. What can you ask for? What should you ask for? This case was brought in September of 24 by the EEOC. And in this case, the pregnant employee was working as a front plate assembler, which means she had to bend over the top of trailers to install wiring. And at 7 months pregnant, as you might imagine, it was painful to bend over the trailers. So she asked to move to another assembly line position or move to light duty for the rest of her pregnancy or some other accommodation. The complaint alleges that the company, Wabash, did not engage in the interactive process and simply placed her on an unpaid leave instead of talking with her about some of these other accommodations that might have allowed her to continue to work. They also asked her physician to complete an Americans with Disabilities Act questionnaire that was aimed at getting information about disabilities and related impairments. But her request for accommodation was not under the ADA. It was under the PWFA. She wasn't contending that she had a disability. And in fact, when her doctor completed the paperwork, he checked the box saying she didn't have a disability, because that's not what this was about, but that's what the paperwork said. And the employer refused to discuss an accommodation outside the context of a disability with this employee. So active ongoing case, and we'll see how that turned out. On the medical documentation topic, here's a slide about the things that you can't ask for under the PWFA. You should not be asking for disability-related inquiries because, again, this PWFA is not about a disability. There might be overlap with the ADA, but under the PWFA, this is not a disability. So if you are asking physicians or providers to complete a form that uses words like physical or mental impairment, limitation on major life activities, and what life activities, that is not an appropriate request under the PWFA. When the limitation and the need for accommodation are obvious, you should not be asking the physician to sign paperwork. And so you should not be asking the employee to go get a note from her doctor confirming that she's pregnant or confirming that she can't bend over the edge of a trailer because her stomach is obviously extended due to her pregnancy. You should not be asking for documentation in the virtually all situations that Jenna talked about. You should not be asking your employee to have the doctor write her a note that says she gets to go to the bathroom more frequently than other people. And then if the employer already has sufficient documentation, you should not be going back to a provider to ask for more information. So as accommodations evolve over the course of a pregnancy, you may already have enough information to deal with that accommodation request, and you shouldn't be going back to the physician. What should you ask for? First, you're not required to ask for anything, so decide if you need to. Does the worker have a physical or mental condition? That's fair. Is it related to, affected by, or arising out of pregnancy, childbirth, or related medical conditions? And if the answer to 1 and 2 are yes, then there is a known limitation that may need an accommodation. You want the physician to tell you what that adjustment might be to a work rule or work process or a work function. And if yes, what is that? That's really all you should be asking for from a provider if you find that there's a need to ask for anything. Okay, hold on while we switch hats. But you've been listening so far, this audience, as employers of people who need accommodations, but many of you are healthcare provider employers. And so we switch hats to talk about some guidance that came out, I don't have a date on this, recently, December. It's guidance that's aimed at healthcare providers, who may also be employers, but the provider that's completing the medical documentation requests it's receiving from an employer. And the guidance that the EEOC released talks a lot about the provider acting in an advocacy role, referring their patients to resources about the PWFA, suggesting possible accommodations, researching what those might be with the Job Accommodation Network. So the EEOC wants the providers to be an advocate for these pregnant people. Don't have to be the treating provider. You could be a telehealth provider if you are completing PWFA paperwork. You shouldn't be providing a diagnosis because, again, this is a variety of conditions that might not be an impairment or a disability. Don't overstate the need for particular accommodation is one of the things the EEOC recommends to providers, because it may very well be that there is an alternative that needs to be considered. And if you as a provider are saying this is the only possible accommodation and nothing else, you may be boxing your patient in. And then don't just provide the medical records to the employer. That doesn't really fulfill the advocacy role. And then you may be providing much more information than you need to the employer. And then the EEOC tells providers that if you get a form that seems overly broad and is asking for a lot more information than it needs to, the EEOC advises that you just don't complete that form and you mark it as inapplicable. So we can switch back hats again to being an employer, but this is the time where Jenna and I want to remind all of the healthcare provider employers on the call that this is traditionally has been a really sticky situation for healthcare provider employers because you've got to wear your employer hat. You can't wear your provider hat. And particularly when you're in a situation where your employee is coming to you as a provider for paperwork related to their employment, you really have to be careful that you are not trying to diagnose your employee or decide what's best for them. If there is an HR department, you should really leave this PWFA accommodation to the HR department. Okay, quickly then, EEOC has some other cases that cost employers a lot of money under the PWFA. So here is a $50,000 cost to this employer who refused to give accommodation for monthly medical appointments related to pregnancy. Here's a $92,000 settlement when the employee asked for 6 weeks to recuperate and grieve after a stillbirth. Without engaging in the interactive process, the employer fired her, and that cost them $92,000. In this case, it cost $40,000 for the employee who took leave from a manual labor job. And then when she was ready to come back, they told her there was no work available for her to come back. But lo and behold, they had hired additional laborers anyway. And they ended up settling that case with the EEOC for $40,000 plus all the things that come with a consent decree settling with the EEOC. Jenna.
Thanks, Barbara. We're getting a lot of really great questions, so I'm sorry we're not going to be able to jump into all of them. And some of these slides that we're coming up to will address your questions. We got a question about kind of coverage, who's covered, are trans men covered, are women who have hysterectomies covered? I think the way to think about this is the accommodation being sought related to that person's ability to get pregnant, be pregnant, carry a child. And that's who is covered by the PWFA, and that's who's intended to be covered by the PWFA. The person who's in that process of getting, is already, or just was pregnant. Okay, so other laws that apply to pregnant workers. There's a bunch, so let's just dive into this. Title VII of the Civil Rights Act, 1964 law, the big anti-discrimination law. It was amended 14 years later by the Pregnancy Discrimination Act. And that expressly changed the language of sex to include pregnancy. So you can't make decisions based on pregnancy. You can't fire somebody because they're pregnant. It is not, the Pregnancy Discrimination Act is not an accommodation statute. The PWFA is the kind of first time that pregnancy itself is something that we're accommodating for. Barbara will talk about the ADA and what's covered, but pregnancy by itself is generally not a disability under the ADA. In terms of the Pregnancy Discrimination Act, that's really a comparator statute, meaning we're to consider how we treat non-pregnant employees with the same limitation. So that case involved a driver who picked up and delivered packages. She said she couldn't lift during her pregnancy. UPS put her on an unpaid leave. And in that situation, she lost her employee medical coverage. And so she filed a lawsuit. And then she did go back to work, interestingly, and continue to work at UPS after she had her child. And the court was grappling with this comparison. And the kind of key analysis was whether there were people we're treating pregnant women the same as people who are not pregnant, but similar in their ability to work or inability to work. That's the key analysis there. The court said that under the Pregnancy Discrimination Act, pregnant women are not awarded a most favored nation status. It doesn't give them kind of, again, a most favored nation status, which is different than the Pregnant Workers Fairness Act. If the Pregnant Workers Fairness Act changes, if the scope of it does change, we will still have the Pregnancy Discrimination Act as an amendment to Title VII to consider.
So the Americans with Disabilities Act is an accommodation statute like the PWFA. And there are some aspects of pregnancy and childbirth and related medical conditions that may also be covered under the ADA. But under the ADA, something has to rise to the level of being a disability. And so the ADA does not provide the types of things that the PWFA provides, like these predictable assessments or virtually always being able to sit or eat or drink or use the restroom more often. The ADA does not contemplate that you're removing an essential function of a position as an accommodation. Although I will say that in my practice, it often makes sense to consider whether on a temporary basis there are changes that can or should be made, and not just get tied up too much in the, is it an essential function or not? But that is still a standard under the ADA, and it's not under the PWFA. And then the ADA also wouldn't provide accommodations that a pregnant person might need to maintain their health and a healthy pregnancy. Because again, the ADA is only focused on disability, and maintaining health or a healthy pregnancy aren't disabilities. It's kind of the opposite. We talked earlier on about the Catholic organization case and the idea that IVF in some instances may not be considered to be a related medical condition. Excuse me. Under the ADA, however, infertility may also be covered if it rises to the level of a disability. Excuse me. Under the ADA. So even if those regulations change, even if they change for certain parts of the country or certain types of employers, don't forget that the ADA may cover infertility. And what's interesting about the infertility is that on February 19th, the Trump administration issued an executive order where they're talking a lot about the desire to expand access to IVF and infertility treatments, potentially to make it drastically more affordable. So I think it'll be interesting to see how that desire to expand the access to IVF ties in with the different court challenges trying to take IVF out of coverage of the PWFA. But don't forget about the ADA. Jenna?
Thank you, Barbara. The next overlapping statute, we had the Pregnancy Discrimination Act, the ADA, and now we have the PUMP Act, which is an acronym, and I did have to look up what it stands for. It stands for Providing Urgent Maternal Protections. And so this was an amendment to the FLSA, the Fair Labor Standards Act. So we're talking about wage and hour overtime land right now. And it applies to all organizations that are otherwise subject to the FLSA. The two big requirements under the PUMP Act relate to time and space. So the time requirement is reasonable break time to both exempt and non-exempt employees who need to pump at work for 1 year after their child's birth. And for those of you who are saying, what does reasonable mean? That is a very good question, and we'll defend on the facts and circumstances of the situation. The second requirement of the PUMP Act is space. So employers have to provide a space other than a bathroom that's shielded from view, free from intrusion from coworkers and the public, and that may be used to pump breast milk. So here are just a couple of examples, and I think other folks are asking about similar situations. What if an employee wants to pump longer than a year? Well, the PUMP Act says that it's up to 1 year. The PWFA is not so limited, and I've had this situation come to my attention before, where if we are beyond the year, it goes to whether it is reasonable to allow the employee to continue pumping. What happens if an employee needs 3 40-minute breaks to pump in a 10-hour shift, or there's a 12-hour shift, and these breaks are longer than the total amount of time that an employee is granted for breaks under state law or federal law? And what if an employee requests curtains or another barrier be installed rather than using a separate space? So again, the PUMP Act is pretty cut and dry in the sense it's an FLSA rule. It's not so much in the world of, well, what about this and what about that, and the interactive dialogue. If an employee asks for curtains or another barrier be installed to breastfeed or to be able to express breast milk for their child, that's probably an accommodation request under the PWFA, in addition to a request under the PUMP Act, and should be evaluated in that way. Barbara?
Yep. Okay. So FMLA, the FMLA, we've had a lot of questions about that. I don't think you would really consider the FMLA and the PWFA to be alternatives. I think they really fit together, and you would probably consider using them together. The gap that the FMLA has, though, that the PWFA fills, is that FMLA is only leave and job protection. It's not about accommodations. The FMLA only does not apply to smaller employers, but the PWFA does. And so, it provides wider coverage, the PWFA, than the FMLA. And that you would probably, if you're giving leave as an accommodation under the PWFA, be looking at running that concurrently with the FMLA. So we've had quite a few questions about if somebody's taking time off for medical appointments, can it just be FMLA and not PWFA? I think you really need to think about how they fit together. And it's an accommodation under the PWFA that might count against this person's FMLA bank of time. But I caution you, if they've gotten through the FMLA bank of time and for some reason need to have additional accommodations under the PWFA, such as more leave, you need to consider that under the reasonable accommodation analysis that Jenna has set out. Okay, state laws.
Thank you. We're flying now. 30 or so states plus DC have their own state level provisions on pregnancy accommodations that are similar to the PWFA, and they're coming from across the country. So I put 2 examples up there. I should have highlighted the difference between the two. It's kind of like those games you can spot the difference. Both of them require reasonable accommodations for pregnancy, childbirth, or medical or common conditions related to pregnancy, unless there's undue hardship. But South Carolina's expressly says provide reasonable accommodation to employees with medical needs arising from pregnancy, childbirth, or related medical conditions. So know your jurisdiction is kind of the big guidance there, but there are state level protections that match the PWFA, and also city-specific protections like in New York City, Philadelphia, and Providence, Rhode Island. Okay, we made it to the end of our slide deck. Thank you so much for joining us today, and we hope the information was helpful to you. As a reminder, this program has been approved for legal education hours. So to report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your business needs. And if you need anything, Barb and I and the rest of the Husch Blackwell team are here for you. This concludes our webinar. Thank you.